The Fall 2020 Hinkle, Pryor, and Fischer Parent Empowerment Conference. Realities for a New Reality. 2 days, 25 workshops, renowned speakers and presenters, by families, for families, nearly 40 hours of unfiltered and straightforward information, made possible by the leaders in disability rights advocacy for over 45 years, Hinkle, Pryor, and Fischer, attorneys at law. So welcome to this session of our ongoing encore presentation series of the Fall 2020 Hinkle, Pryor, and Fischer Parent Empowerment Conference.
Great. So welcome and thank you for attending the Hinkle, Pryor, and Fischer Virtual Parent Empowerment Conference. My name is Jared Oberweiss, and I will be your moderator for this workshop entitled Able Accounts and First Party Special Needs Trusts. Our presenter for this session is Tina James. And before we begin, all participants are currently muted, and we would just ask that you remain muted throughout the session. The workshop will last for about an hour, and if time allows, the presenter will take questions at the end. Please ask your questions in the chat feature in the control bar, and I will ask as many of them as I can, again, time permitting. Also, if you've not already done so, I highly encourage you to sign up for this keynote address, which will be delivered by former New Jersey Supreme Court. A world where everything changed and nothing changed. Justice Holmes is also the parent of an adult child with autism and will be providing a unique perspective on the times in which we live. She is both an inspiring person and inspirational public speaker. You will not want to miss this. Simply go to the conference event page, click on the agenda tab, scroll down to the keynote, and you can sign up. It is now my pleasure to welcome our presenter. Here, her legal work focuses on these access appropriate services. Before working as a litigator with a national law firm, she served as a judicial law clerk in the New Jersey Superior Court. She successfully argued before the Florida Supreme Courts. Tina was selected for inclusion in the Super Lawyers Rising Stars in 2015 and 2016. Tina received her Juris Doctorate from Rutgers University School a degree from Rutgers University Douglas College. Personally and professionally, Tina is committed to promoting all aspects of diversity and inclusion. She volunteers with a variety of nonprofit organizations serving children and is a past member of the board of directors for the council. Tina lives in central New Jersey with her husband, Andrew, her 2 stepchildren, and their daughter. At this point, I'll pass it along to Tina. It's all yours.
Good morning, Jared, and thank you for that warm introduction. I'm excited to be here today speaking with everybody on ABLE accounts and first-party special needs trust. And so what I want to do is start off by giving you a very big picture overview of what we're going to cover in today's presentations. I'm going to start off by explaining to you what is an ABLE account. I'm going to talk why would you set up an ABLE account. We're going to talk about who can have it, how would you even fund it, and then what are the benefits and limitations of having an ABLE account. We're going to move on to the first party special needs trusts. I'm also going to give you an overview of third party special needs trusts and just trust in general, so you understand how this is different and unique, and also talk about why that would be set up, what situations where we would want to use that. Again, how would that be funded? Why would it be funded? How you would even administer that trust and pay for things out of it. And then we're going to kind of compare the two back and forth. The way I explain ABLE accounts and special needs trust and even the other estate planning documents that we use, that these are tools, right? And so these are tools for you to have like in your arsenal as you need them. And they will work for some situations, they may not work for others. But I think it's very important for families to know what options are out there and how they can be used. So in case that situation arises, where you might need that. So let's dive into what is an ABLE account. ABLE account, it stands for Achieving a Better Life Experience. It is a specific type of investment account, like a bank account, that it's a safe way for an individual with disability to save funds without jeopardizing means-tested government benefits like Medicaid and supplemental security income. And why is this important that we have a type of account, a savings account that doesn't jeopardize them? Well, that's because these means-tested government benefits have limits, not just on the income that a person can use, but they also have a limit on how much resources a person can have. And generally speaking, and just for the sake of this presentation, we're going to use $2,000 as the number. And generally speaking, an individual who's receiving means-tested government benefits cannot have resources that exceed $2,000. And so, that could easily happen. They get a gift, they get multiple gifts for, a celebration in their life. Maybe they graduate from high school and, family members send them checks and things like that. At that point, they're in college, many things could happen where they end up receiving money. Somebody could pass away in their family, leave them money. Or maybe through the course of their lifetime, grandma and grandpa may have been giving them savings bonds, and parents may have buying that. And then all of a sudden they have accumulated, this money. And so this ABLE account allows a person to set up the account, and we'll talk about who can set it up, fund that account, and have it not count against that $2,000 limit. Now, of course, there's a catch with it, and we're going to talk about, the drawbacks to it, but it's important to know, why you would even consider this. And so who can have an ABLE account? So this is an individual with a significant disability, as long as that condition, that disability started before that person turns 26. And if the person meets the criteria for supplemental security income or disability, then they've met the criteria, as long as the age criteria also applies. If they don't receive SSI, but the disability did start before they were 26, then they must show that in other ways. So what they would do is they have to show the condition is severe, that it's lasted at least 12 months, and that it prevented the individual from earning substantial and gainful income. And this requires a doctor's certification about their condition in order to qualify them to open up the account. And if you're opening up the account, there is a website, and I tell people the easiest way to get there is to go ahead and just put in the Google search bar, NJ ABLE, ABLE, and it'll bring you right to the link. It's the top hit there. And that's how you would go in and open up this particular account. And it's through Fifth Third Bank. There's a couple options to how the money can be invested, different more conservatively or, a little bit moderately riskier. But that's up to, the person setting up the account. And it comes with it's a checking account, comes with a debit card as well. And so we'll go on a little bit later in the presentation about how you can spend that money and what you can spend it on. But that's the way you go about setting it up and starting it. And so the benefits of having an ABLE account is that the funds in there, like I said, don't count against the Medicaid eligibility. And a person's able to save up to $100,000 in this account before it even starts to affect supplemental security eligibility. So again, if somebody has that income, and they need somewhere to put it, maybe they are working and they have some income coming in, this is a great way to save that money. There are some limitations on an ABLE account, so some drawbacks. I mean, the first thing is that you can only deposit a maximum of $15,000 into an ABLE account. However, if the individual is working, that limit is slightly higher because they can contribute up to, for 2020, the amount was $27,000 into the ABLE account. But the difference between the $15,000 and the $27,000 is from their earnings. But generally speaking, again, we'll go with the $15,000 numbers, what can be deposited into an ABLE account. And those deposits can be from other people as well. So again, like I talked about, receiving gifts, grandma and grandpa want to give money, that's the place that you can put this account. Now, of course, there is a drawback and there is a catch because, the exchange is, okay, we're not going to count this towards your resource limit for your benefits. But the catch is that when the person passes away, the person with disabilities, any money that's remaining in this account gets paid back to the government to repay the government liens for those benefits that they received during their lifetime. And so it's important to know that, while this is a great way for somebody to save money, especially if it's their own money and they're earning it, the drawback is, again, it gets paid back after they pass away. So this isn't a substitute for like estate planning purposes. If you're a parent and you want to make sure that you're passing your assets down to be used for your children, and maybe you want that to pass to your grandkids, because this isn't the way you would go with that. That's a different presentation. That's a different day. But this is a way, again, very specific. It's a specific tool. One of the other things that's very unique and fairly new for the ABLE accounts is that you can put rollover contributions from a 529 college savings account. So sometimes families have this come up where they're like, okay, we started a 529 savings account when my kids were younger and didn't realize that obviously, this child wasn't going to go to college. Now what do? I have this money set up in this account for them, and it's been growing somewhat, some tax benefits on it, tax-free growth on the account itself. But what do I do with this now? They're not going to use it. I mean, again, there's separate ways other options you could do with it, but one option is you can roll it over into an ABLE account for that same person. So if they are the beneficiary on the 529, then they are also they're the owner of the ABLE account. You can roll it over into the ABLE account for them. The catch again with this is that that's still limited to that maximum of $15,000 per year for the annual amount that they can have in the account. But it is a really neat feature of an ABLE account, and something that can be used to help transfer that money and still use it for the person that it was intended to be used for. And so once you have the money in the ABLE account and it's set up there, what can you spend the money on? And this is important to keep in mind. It does have some limitations on what you can use it for, but there's quite a bit of things that you can spend the money on. So a qualified disability expense is, what Social Security says that it can be spent on. And they define the qualified disability expenses to be the following things. So education, housing, transportation, employment training, support, assistive technology services, health, prevention and wellness, financial management, administrative things like legal fees, any expenses that might be set up for setting up the ABLE account, any oversight for that, funeral and burial expenses, and then basic living expenses. So it is pretty broad as to how this money can be spent. But one of the key differences, and we're going to really pull this apart as we talk more about the first party special needs trust, is that money in the ABLE account can be used for housing. Again, it has to be very careful when you do. There are some timing issues. However, this is a key difference, and so we talk about having it as a tool, something that's ready to go, or can fill a void in a specific situation. This is that situation. So we talk about the housing, and I want to bring up one other point with this is there is a timing issue. If you take money out of the ABLE account intended for housing, and let's say you put it into a checking, let's say the person has a checking account for their day-to-day expenses, where they might deposit some of their supplemental security income, maybe they put their earnings in there, they have the checking account for that, and they have the ABLE account separately. If they move money over to that checking account and it's intended for housing, it has to be used in that month that they move it over. If they keep it and it rolls over to the following month and don't spend it out for housing, it then gets counted as income. So you want to be very careful that if you are using for housing to pay rent, things like that, that you take time to sit down with an attorney or talk to someone and read up on the rules and make sure you understand that timing issue so you don't end up having it count as income as well. So comparing this to a special needs trust, and I want to make sure I give you a good understanding of what a special needs trust is. There are two different types of special needs trusts. And there's actually a whole bunch of other trusts for whole different purposes, but I want you to understand the difference, and then we can delve into this first party special needs trust, and again, why it's set up, why it's used, and how it compares to the ABLE account, and how it works, collaboratively. So a special needs trust, generally speaking, is a trust where funds are deposited into the trust, and the funds in this trust are not counted as a resource for the person with the disability. So same situation like the ABLE account, where again, we have to worry about our means tested government benefits. We're going to use the $2,000 as the resource limit, and money that goes into this special needs trust, whether it's a first party or a third party, does not get counted against that $2,000 limit. So that's pretty cool. Unlike an ABLE account, and we'll go just a little bit more, there's not a limit on how much you can put into the trust, right? So the ABLE account, we have limits. We can't put more than $15,000 a year. We can't put, we go over 100,000, then we have to start to worry about, the triggering, other resource limits. So there's no limit on the amount that could be deposited at one time into this trust. Funds that are in the special needs trust can only be used for the sole benefit of the beneficiary of the trust. We're going to pull that out a little bit further. Funds cannot be used for food, clothing, and shelter. And the logic behind this is that the government says, okay, so here we are providing you with Medicaid, SSI, SSDI. Those benefits are meant to cover, at least the SSI, SSDI, your food, clothing, and shelter. In theory, we know that that amount of money doesn't go far, but in theory, that's supposed to cover that. And so the exchange is that this trust, we're not going to count it as a resource, but it can't be used for the same thing that we are giving you a benefit for. So what can it be used for? And we're going to pull this out further. Therapies, trips, recreations, other supports, things like that. I talked about there's two different types of special needs trust. And the first one, the one we're talking about today, is called a first party special needs trust. The reason why it's first party is it's created with assets that belong to the individual with the disability. So it's their assets that are in their name, that have, again, maybe it's accumulated savings bond, maybe it's an inheritance, that's their assets that are then being placed into this trust. This is sometimes referred to as a payback trust, an OPRA 93 trust, or a D4A trust. The other type of special needs trust is a third-party special needs trust, and that's set up and created by someone other than the person with the disability. And so this is created by mom and dad, grandma, grandpa, usually mom and dad, as part of mom and dad's estate plan. And so not all trusts are special needs trusts, right? It has to have very specific language in it. It has to clearly delineate who the beneficiary is. And so this has to have specific language in it, not just about with a first party special needs trust, not just about the beneficiary, but also referred to as a payback trust. There is a payback provision. And that has to be detailed out in that as well. There are a lot of other trusts, and people will sometimes come to us and say, I have these other trusts set up, and trusts are set up for a whole bunch of different reasons. So I want you to understand that, there are trusts that are going to reduce your estate taxes, ones that are going to try to preserve family wealth, other ones, maybe they want to protect minor children, or maybe prevent assets in the event of a divorce, or maybe there had been a divorce and there's like a remarriage, you want to protect assets, you might put them into a trust. So there's these other types of trusts that are out there, and they all have different purposes, so they all need different language that's specific to what it is. But all of these other types of trusts, I'm just kind of mentioning generally, those will jeopardize the government benefits for the individual with the disability. So if grandma and grandpa have set up maybe a trust to preserve their family wealth, you need to be careful because that could jeopardize your son or daughter's benefits. And so want to make sure it's the right type of trust for this job. So the difference between these two types of trust, the first party special needs trust and the third party special needs trust, not only is it who puts the money into the trust, but also what happens when the person with disability passes away. right? And with a first party special needs trust, there's this payback provision, much like the ABLE account, where the money gets paid back to the government when the person passes away. So that's what the first party special needs trust. And with that comes regulatory oversight. We're going to talk about what that is. But that is a lot more going on with it. And that's why we're delving into that today. The third party special needs trust, and again, I want to make sure you understand the difference, because a lot of times people use these words interchangeably, special needs trust. When you set that up, mom and dad, you get to decide who the beneficiary is on the other end. So you get to say, okay, if my son or daughter that has a disability, I set this up for them. When they pass away, I want it to go to maybe my other children. Maybe I want it to go to my grandkids. Or maybe there's an organization that's been amazing and very helpful and supportive of my child, and I want to make sure that I donate to them afterwards. Like, you get to decide and control those assets. And so obviously that's part of a whole comprehensive estate plan. My colleague Paul Pryor is speaking on that tomorrow morning, so if you want to know more about that, check out his presentation. But that's a third party special needs trust. So for the first party special needs trust, we have funds that belong to the individual. At the death of the person, anything that's remaining has to first go and satisfy the Medicaid lien. And if they receive services from DDD, they can get into the action too on this. But usually, even if there is any money left over in that trust, usually the cost of these liens for the medical assistance and the other services and supports they've received throughout their entire lifetime far exceeds what even remains in the trust. The other piece with this is that because they are the contingent beneficiary, they're who gets paid back down the road, there's a lot more regulatory oversight. What that means is that you need to provide an annual accounting of the trust. And that's not just, here are some bank statements. Being able to document all of the expenditures that were made from the trust throughout the course of the year. That involves good record keeping, making sure you maintain receipts, and making sure that you also not only maintain the receipts, but you're also clear about who benefited from that purchase. And we're going to talk about that. So annual accounting. So the other piece, I said there is regulatory oversight here with the first party special needs trust. And that's if you want to spend more than $5,000 for any one expenditure, you need to give the division Medicaid 45 days notice prior to making that expenditure. And so that's definitely something, again, it becomes, more of a responsibility on the trustee to oversight, to oversee that. And then also they need to be aware of these obligations, because if you don't give notice, then, obviously then you're going to be met with challenges, objections. You might end up in court fighting over it, where they might challenge the expenditure from the trust. And so why would somebody even set up a first party special needs trust? And I mentioned the whole bonds thing, and you're like, okay, that's small enough. We could use an ABLE account for that. Sometimes we have other reasons why we need to set this up. And perhaps there is a lawsuit or personal injury settlement, and that means the person has a large chunk of money that's too great to put into the ABLE account, but it needs to go somewhere because we want to make sure they can stay on their benefits, or we want to make sure they can qualify for their benefits. That's where we're going to put that into a first party special needs trust. Sometimes they improperly receive an inheritance. Recently I had something where, a very, very remote cousin passed away and didn't have a will. And so it got paid out to a bunch of the distant cousins along the way, didn't have a lot of other family in between. And now this child has $20,000 that it's over the ABLE account amount, and it's going to jeopardize their benefits. So where does it need to go? It needs to go into a first party special needs trust. And so this type of trust usually requires court approval. So we would file a petition with the court. We would say, here's the situation. The child has this, they're receiving government benefits. It is essential and important that they maintain those benefits. This is the money they have. Here's a copy of the trust. We want your permission to be able to establish this trust, deposit the money in, And 99% of the time it's, smooth sailing, the court grants it, and then we establish the trust itself. But it does require court approval. So it is, again, if we can avoid having to use this, again, that's a cost there. So in terms of mom and dad, you're planning, you want to think about planning for yourself so your child doesn't end up with an inheritance and we don't have to go this route. And then again, you can control the legacy of any of your hard-earned money by deciding who it would go to next. So first party special needs trust is set up, it's funded, and on a very basic scale, a lot of times they're like, okay, so I have this piece of paper saying, here's my trust, and we get an EIN for it. It's a tax ID number for the trust, because all trusts, they're an entity that's separate and apart from the person, so they have their own tax obligations for income as well. So I have this piece of paper for the trust agreement, I have my EIN number, I have the court order saying I can put the money there. Now what do I do? So you're going to want to go to a bank and go ahead and open up an account. So the trustee, whoever's the trustee of the first party special needs trust, will decide where they're going to open that up, where they want to bank, depending on the amount that's going in there will also drive their decisions. So opening up just a regular savings account or a regular checking account, you need to check if it's a lot of money. You need to check to see what the insurance limits are. So like, bank accounts are FDIC insured up to, I think it's 250,000, maybe it's 100,000. I'm not sure exactly. You got to check on that. So if you have a $300,000 inheritance that's going into, a trust account, you need to make sure that you're putting it somewhere, that it's going to be safe, because your job as the trustee is to manage this money and protect it. And then also, depending on the amount that's needed and how much you might need on a daily basis for the person with disabilities, maybe you want to invest it and put part of it into an investment account. And sometimes people will have two bank accounts set up for the trust, one where the bulk of it's invested, the other one where they move money over for expenditures on a periodic basis. So that's from a practical side of just getting it set up after it's been approved by the court. So now you want to use the trust itself. You want to spend the money. First of all, the money in the trust must be spent for the person with the disability. I mean, it goes without saying, but sometimes that's a gray line. Sometimes it's not very clear in terms of what is or what isn't. An example that I recently had, I have a family I'm working with, and they had gone to a concert, and their son is blind and needs a caregiver with him at all times. Walk him to the bathroom, to a seat, to find everything. And they, again, you're entitled to pay for, obviously, the person with the disability, and then a caregiver. So if we're talking about vacations and other things, you can pay for a caregiver to go along if that person needs that, if they're not able to travel without a caregiver. In this case, the person needed a caregiver to attend the concert. And there was some pushback from the division as to who else was at the concert. Weren't there enough other people there to watch out for him and take care of him? But no, it was for the sole benefit. Yes, that person does, receive some benefit from attending it, but they, that person cannot attend the concert without having a caregiver. So they need that support there. And so that's where things become a little bit gray, because and this is where we'll see pushback from the division, on expenditures and things like that. But for the sole benefit of the person. It also can't jeopardize, when you make expenditures, it can't jeopardize their other government benefits. So if they're receiving, SSI, you want to make sure that it's not used for food, clothing, and shelter. First party special needs trust cannot be used for housing, right? So this is where it's going to differ from the ABLE account. And that's why I said we got to think about these as tools that we can use as needed. Differs from the ABLE account in that regard, because the ABLE account can be used for housing. And so the first party special needs trust can't be, although a trust can own a home and purchase a home. So that's different. It's usually spelled out in the trust document itself. So when there's court approval, that's approved that a trust can do that, but generally speaking, a trust can't use money to pay rent. We're going to talk about how we can work around that between using an ABLE account and the trust itself. But outside of that, generally money can be used and spent on a whole host of other things for the persons. This includes things like vacations. Obviously, we want to make sure they can continue to take vacations, they can enjoy things, outings, activities, furniture, if they need furniture, personal care products, if they need extra therapies that aren't covered, maybe electronics, maybe they have a tablet or a computer, or maybe they want an assisted, a device that's not covered by insurance. Entertainment, going to the movies, and so those are all types of things that the money can be spent on. But again, first and foremost, it can't be used to jeopardize those benefits, because if it is spent that way, what ends up happening is it gets treated as income. So if you were to go ahead and spend money on clothing, then SSI is going to say, okay, we're going to count that $100 you spent as now the person receiving $100 in income. And then obviously that reduces what they're receiving with the SSI. So it does have a snowball effect as to how it will play out with the benefits and how things are obviously you don't want to spend the money from it, period. You want to always play on the safe side because you don't want to be fighting over the expenditures. But if it did happen, that's what ends up happening, is it gets counted as income, and then it could jeopardize their benefits completely. So always err on the side of caution with trying not to jeopardize their benefits in any form. And this, not overlapping with their benefits is called, supplementing. It's a supplemental trust. It's called supplementing their benefits, not supplanting their benefits. So you hear that phrase thrown out a lot by attorneys, by other presenters, it needs to supplement benefits, not supplant them. This is what they're referring to, is making sure that those benefits are treated one way and then you're providing everything else with the trust. And the other thing we talked about is that sole benefit rule, that the person who's the beneficiary is the sole benefit of who the money is spent on. And again, you have an annual accounting requirement. And that's why I said when you are keeping track of expenses, it's important to track not just what the expense is, but who went there as well and who benefited from it. Because if somebody else benefits from it, the idea is that the requirement is that they need to pay back their own pro rata share based on the benefit that they may have received. And that's, again, so keeping track of it, does help with that. Keeping track of if there were any contributions from somebody else, like, we went to the concert and, this is my pro rata share. Again, my example is different because that person needed the caregiver there exclusively for that. And that's what that person was hired to do, to go there and be that caregiver. So stepping back, covered a whole lot with the ABLE account as to why we would set it up. We have this money. We also, who can have it. We talked about how it might get funded and some of the benefits and limitations on it. And then coming over to the first party trust, we talked about, again, why would we set it up? Again, we have, obviously more than 15,000 because we're going to need, otherwise we could use the ABLE account. Why we would fund it with that, how we would fund it, we would use the court, to get the approval and then open it up, and then administering the trust, again, making those expenditures and annual accounting. A question that I get frequently is about trustee fees. This is a lot of work. Is there any, do I get paid for my time in doing this? And there, trustees are entitled to a fee for their services, not just with this trust, but any trust. And there's a statute that details out what those fees are. It's a percentage of the amount that's in the trust. And that's for both types of trust, the first party and the third party special needs trust. If you are a trustee of a first party special needs trust, you should make sure you are taking your trustee fee, because again, like we said, at the end, when your son or daughter passes away, anything left over is going back to Medicaid. So we don't want that. We want to make sure that you are compensated fairly for your time and what you do. A lot of people say, well, I don't want to spend my child's money. But if your child's not going to benefit from all the money that's in that account, all you're doing is saying, I'm not spending money that's going to go back to the government. So again, you're doing the work. It's meant to compensate you for that. Again, so if you're taking that trustee fee, again, it's important to, again, speak to an attorney, speak to an accountant, make sure you're calculating that correctly, and you document that on your annual accounting. And so that way, they understand what that expenditure is for. So comparing the ABLE account and the special needs trust, that they are both very similar in that we have this payback provision. We have the money going to Medicaid, and possibly DDD after somebody passes away. So they're very similar in that regard. The amount that can be contributed on an annual basis into the accounts is different. I mean, the ABLE account is $15,000 per year, and once we get up to $100,000, it starts to jeopardize resource limits. So we always have to be aware of that. Whereas the special needs trust, there is no limit on what can be deposited in at one time. Usually it's in one lump sum. Occasionally with personal injuries, or sometimes there's an injury at birth and there's settlements where they have an annuity being paid out on a regular basis, you might have ongoing payments into that trust. So, but there is no limit on what's going into that trust, like the ABLE account. But what is different is that you can use the ABLE account on housing where you can't use the first party special needs trust on housing. And one of again, think about these as tools, and we work together, with these different tools. One thing that you are allowed to do is you are able to fund the ABLE account. Oh, I said that. That's a little silly with the amount of ABLEs I said there. It is possible to fund the ABLE account with money from the special needs trust. So you have money in a special needs trust and you say, you know what, my son or daughter, we need to use this for housing, to pay their rent, whatever it may be, to those housing expenses. Well, what can we do? We can move up to $15,000 a year over into that ABLE account from that special needs trust. So why was I harping on providing the 45-day notice to the division? Is because that's an expenditure over $5,000. So you want to do something like that, you need to make sure our timing is right. And now if you're going to move that money over there, you give them the 45-day notice, you start that clock ticking, and send that letter out and say, I'm going to move $15,000 over into the to the ABLE account. And then once that time passed, there's no objections to it, and this is something that they don't object to. It's something that's allowed, it's permitted, so you just have to provide them with notice. Go ahead and do that, and then move that money over. Now that money is in the ABLE account, and you are able to use it for rent. So as I said, I think it's important to keep in mind how these two things work together, how they're different, what the benefits are from some of them, and what they are from others. And there was, just switching over, so, and I mentioned the example of, the concert with, one of the families that I'm working with, but we also have, a lot of times you're going to see with the first party special needs trust, the government agencies really try to limit how you can spend that money. In their mind, they're like, hey, listen, we're the contingent beneficiary and we want to get as much as we can on the back end. And so this is very, very frustrating with families to be going through this constant, almost like a tug of war with Medicaid over these expenditures. But it is something where they do try to limit that. And so again, keeping good records, making sure that you provide them with notice when that's important, it will really help to kind of eliminate that back and forth, that tug of war regarding that. The other question we get a lot, and this is about in both types of trusts, is when do you need to share the copy of your special needs trust? And so you only need to share it when it's funded. So a lot of times people will set up a special needs trust, that's the third party, the other one we talked about, with part of your estate plan. It's not funded until you pass away, there's no money in it, don't have to do anything with it. The first party special needs trust, most of the time it is set up right as it's being funded. So it needs to be funded. And so, at that point, you are going to have to provide copies and with the annual reporting. And then if there's other annual reporting you have for when you're getting recertified for different benefits, you should make sure that you put down the trust information on that as well. So I know I covered a whole bunch of information here about the difference between the ABLE account and our first party special needs trust. One other consideration that I want to just bring out there before I'm going to turn to some questions is I get a question a lot about the trustee and who should be the trustee of a special needs trust. And so when you have a first party special needs trust, again, this is a type that's being set up because it's needed right now. And usually at that point, the parents are listed as the trustees, right? And then whoever survives of them is, can serve as the sole trustee. And then they should name a backup trustee to make sure that, again, that something should happen to them. There is somebody who can step in and manage that trust on their behalf. A lot of times when you're setting up like a third-party special needs trust as part of your estate plan, that's something that happens and gets funded when you pass away. So that consideration is a little bit different. But even when you're thinking about the successor to yourself in either context, you want to think about somebody who is going to be able to, I say they need both, both types of skills. They need the hard mathematical, logical skills to be able to, again, deal with some of the accounting and the reporting requirements. But on the other hand, they need that soft people skills. So they need to know what your son or daughter needs. They need to be able to assess what expenses are necessary and make sure that those comforts that they have and things that they've been doing while you were here, they can continue to do. So you really want to think about somebody who has both of those skills in place. Occasionally, we will see, depending on the size of the trust, we will see a corporate trustee, maybe as a co-trustee. Usually that's for larger trusts, 350,000, 500,000. There's pluses and minuses to having a corporate trustee as a co-trustee. One big benefit is that, again, their record keeping is usually outstanding because they're a bank and everything is logged and documented very well. The downside is sometimes it is difficult to get approval for expenses because they are more conservative. So it's good and bad on both ends, but that is just something and then Plan New Jersey is a nonprofit. They will serve if there is no family member, no one else out there, and this is a total last resort. They will serve as a successor backup trustee in that situation. But again, it's very specific as to when they're able to do so, and to be named as a successor. You do need to provide them with the okay and get their approval ahead of time, but that is always an option. I do get that from families sometimes, like, what if I have nobody else? But it's always better to think about somebody who, again, like I said, has those skills, and especially those soft skills to know your son or daughter, to be able to make sure those expenses are being consistent with what has always happened while you were here and alive. So I don't know if we've had any questions coming in, Jared, or...
All right, so first, that was a great presentation. That was a lot of very useful information. So thank you very much, Tina. Let me take a look at the chat box. And again, if anyone has any questions and wants to submit them, please do so. I've got a question here that asks about the money going into the trust to the ABLE account will be directed for housing. How does that work?
Right, okay, so if it goes into the trust, it can't be used for housing. So if we want to then direct it over to the ABLE account, again, what we would do is, if we're working with that first party special needs trust, we would go ahead and send notice to the division. We would send out a letter saying, we intend to spend $15,000, assuming you're going to move the $15,000, the maximum amount, over. If you're moving over less than $5,000, then we don't have to. But most of the time, it's because we want to move over the maximum. And we just send out the letter and say to them, hey, this is the trustee, this is what they intend to do with the trust, here's your notice, your 45-day notice that they intend to make this expenditure. We wait out the 45 days. When there is no objection, you take the trust, you write a check from that, and then you go ahead and deposit that check over into the ABLE account for that. So that's a very technical way of doing that, but then once it's in the ABLE account, then like I said, then it's over there, and then you can go ahead and make those expenditures for that.
All right. The next question is, what are the typical management fees for ABLE and special needs trusts?
Okay, so ABLE accounts, and if you pull up the website New Jersey Able, I don't have that in front of me here because I got Zoom up, but there is on there the percentage of what the fees are. They are very, very small for managing the investments on there, and there is some bank fees. Like I said, they are minimal on the Able account itself. The trust fees. There is a statute, like I said, and it's usually a percentage of what the balance is in the trust. And an example is a trust with $100,000. The fees might be like a couple $100 every year. So it's not that it's a lot. Whereas you have a corporate trustee, they have their own fee schedule that could be set. And that fee schedule that's set by them, there's usually language in the trust if you're naming a corporate trustee that as long as it's reasonable, those fees would be approved. And they are usually a lot higher with the corporate trustee. But the two things to keep in mind with the corporate trustee is their goal as the corporate trustee is to keep your money invested and growing for as long as they can. Again, that's why they're a little bit more conservative on approving expenditures. And so even though their fees are a little bit higher, their idea is to help have growth. And so they're going to make sure that whatever growth there is does exceed what their fees are. But so do keep that in mind with corporate trustees. Their fees are a little bit higher. And again, I think it's based off of the amount that's in the trust itself. And there is language in our trust agreements that if it's a family member, they can take up to a certain percentage as well for their service as a trustee. But again, like I said, by statute, they are allowed for that. And it's important that, like I said, if the money at the end of the day is going to get paid back, make sure you get paid for doing your job along the way.
I have another question here that says, are the special needs trust rules the same in Pennsylvania as in New Jersey?
Jared, I'm going to kick that to you slightly. Okay, so generally speaking, special needs trusts are, a creature of federal statute, right? So, it's the federal statute that says, okay, we're going to approve and allow these types of trusts. Medicaid is also federal, so those apply across the board to every state. Now, each state has its own sort of nuances with some of the Medicaid, how certain things are managed and run. And also some of the other supports and services that are offered to individuals with disabilities. So in terms of the rules being the same, I think generally speaking, and again, I'm going to defer to Jared. Jared's licensed in Pennsylvania. I'm New Jersey and Florida. He's New Jersey and Pennsylvania. It can't be spent on food, clothing, and shelter. So that rule is generally consistent across the board. But what I don't know is, and I said we're going to use like the general number of $2,000 as like the resource limit. That there is a lot of variation even within New Jersey as to if you're in like a different program. If for maybe housing, or if you're in a workability program, you might have different resource and income limits, and those are all going to vary. So like I was generally using like a 2,000 general number, and that's not even consistent, here, but that's the most likely number to work with. Jared, I don't know. Again, I'm not throwing you on the spot here, but
no, that's fine. You can do that. So generally speaking, and again, for today's presentation, the answer is yes. At least as far as the special needs trust goes, the rules are ultimately the same. And again, distributions from the trust have to be for the sole benefit of the beneficiary. But I will just make a quick point that if any of you are in Pennsylvania and you do have an ABLE account, the major difference between New Jersey and Pennsylvania is that Pennsylvania does not have a Medicaid payback provision within their ABLE account, which is a vast difference than New Jersey. But if you do have specific questions relating to Pennsylvania, I would encourage you to follow up with our office. We'd be happy to address any of those questions for you.
Well, I learned something today.
You learn something new every day.
I do.
So I've got a question here. Can a special needs trust hold real estate? And the second part of that question is, what happens to money inherited and placed in a third-party trust?
Okay, so can a special needs trust hold real estate? Yes, a special needs trust, both for first party and third party, can hold real estate. It can also, purchase, like I said, purchase and own a home for the individual disabilities. There are a lot of other little requirements and nuances that need to be taken care of if you're going to go down that route. So don't just go out and purchase a condo if you have money in a trust for that. Because if the person with disabilities is living in that home, they still need to pay their fair share pro rata rent for living in that home, instead of the rent being paid to maybe a landlord or somewhere else. The rent is then paid to the trustee. And so the importance of that is, if they don't pay rent, then again, Medicaid, SSI, Social Security will go ahead and count the value of their housing in calculating their income. And so again, we don't want that to happen. And so the way to ensure that it doesn't is make sure that they are paying for a portion of the rent and the living expenses. So the trust would, purchase and own the real estate. They would pay the taxes. They would pay all of the fees associated with that. And then also, based on whoever else is living in the home, they would also have to pay a pro rata share to the trustee. The one thing that, occasionally, we don't see it too often, but occasionally, I've come across is a trust owning an income producing asset, real estate, but that, the beneficiary is not living in. So maybe they have a property that has, a second home or something like that that's been rented out to tenants, and it's an income producing property, and they've passed it to the trust. That's a great way to maintain income coming into the trust on a recurring basis, assuming it exceeds the cost of maintaining that home. It does add a little bit more responsibility to the trustee, because they are not only managing the trust, but then also acting like the landlord for doing so. But like I said, it is one way that families have done an income stream into the trust. I don't see it all that often, but occasionally I have seen it. And the second half of that question, Jared, had to do with the inheritance.
Yeah, so the question was, what happens to money inherited and placed in a third-party trust?
Yeah, so if it's inherited, and I want to be super, super clear about this, is that when somebody dies, if they don't have a will, and that money passes directly to the person with beneficiaries, and let's just say it's Andrew's, the person with disabilities, and it goes directly to Andrew because there's no will in place. He inherits that money. It goes into the special needs trust. You petition the court. We put into a first-party special needs trust. That money is there to be spent, for Andrew, for his life, to, again, supplement his benefits. So the trustee, who's ever named as that, will go ahead and do that. When you set up a third-party special needs trust, and so I just want to be clear about this, that's usually set up as part of your estate plan. And you would have a will, and you would have other documents that we prepare. But when you set that up, your will, what you do is, instead of naming the child with the disability, instead of naming Andrew, we're going to name Andrew's third-party special needs trust as the beneficiary. That money is going to go, you pass away, it goes directly to the estate, and then it goes directly to the special needs trust. Never touches Andrew's hands. And then the part about that's key is that because it never touches his hands, we don't need court approval, doesn't get paid back to Medicaid, and it goes into the third-party special needs trust, and you decide where it goes when he passes away. And so when it's inherited, whether it matters very much if it's inherited under, if there's a will, if there's not a will, how the child receives it as to which path it's going to follow, and then how those are set up. But then once they are set up, once that inherited money is in the trust, like I said, it's there to be spent for that person to supplement their life.
All right, the next question is, if my child receives money directly, for example, through an inheritance, how long would I have to create a first-party trust so that the money would not count toward income and asset limitations and jeopardize governmental benefits? You
want to do it as soon as possible, because and sometimes when they inherit money, what ends up happening, again, depend on some of the specifics here, but if they inherit it and you just find out somebody's passed away, they're going to receive it. It's going to take 6 months to a year before it's paid out. You do have a little bit of time then, but you don't want to sit on that, because if they wrap up the estate very quickly and they send you a check, you need that court approval to put it there. If you find out about it, again, the sooner you can act to get that first-party special needs trust in place is going to be better, because what you don't want to happen is, if it gets deposited into an account and those account balances are reported to Social Security, or there's an annual, like a reevaluation, not reevaluation, annual, certification of your assets that you're doing for government benefits, you need to answer that truthfully, and you need to tell them, accurately, like, this is the assets that he or she has. Doing so is, if you don't, it's fraud. So you need to make sure you tell them, but then you also have the consequences of that. And and if you were in that situation, we could try to work with work with them and let them know, hey, this is going to a first party special needs trust, and buy some time for that. But again, you really want to make sure you act as quickly as you can to get that over there. Like I said, there are some situations where, again, that money's there, it belongs to them, but because of the logistics of whatever's happening, that check hasn't been cut yet. In that case, like I said, you do have some time, but I certainly would not wait. I wouldn't take that chance.
So I have another question here that I think I'll answer because it relates back to the, it asks if can New Jersey residents have a Pennsylvania ABLE account? The answer is yes, but if the intention to do that is to avoid the Medicaid payback provision, you're not going to be successful.
Sounds like my question the other night. I had just to share with everybody, I had a really great presentation, and I had a woman ask me the question if she can get around the food, clothing, and shelter thing by paying for her child to take a year-long cruise, because vacations are okay, and that would cover the shelter for the year and food. And it's a great idea to do that, but Medicaid's not going to look at it that way. They're gonna say, okay, the cost of the vacation is covered in the sense of we'll figure out what that part is, but in terms of the food part of that, and I'm not even sure I'm sure there would be a lot of pushback and a lot of fighting over whether it's considered shelter once it's an extended period of time, like the year. So always thinking, I really like that. People are always coming to us, but.
Another question here regarding regarding using money from a first-party trust for travel or entertainment. Who determines if a caregiver is required for the person with a disability? The second part is, when would a caregiver have to pay back his or her prorated portion of the cost?
And so again, that's going to vary, right? So that's going to vary on the nature of the disability. For the person, it's going to vary on maybe what supports they're receiving and not receiving. Again, we can't overlap with other supports that they're receiving. But if, the decision as to whether or not, your child or, adult child, whether they need something, again, it doesn't overlap with benefits and it's for them, that's a decision that, the trustee makes, right? So their job, and that's why I said the soft skills are and not just soft skills, because, but it's very important for them to understand the nature of the disability and understand the nature of what's happening. So if you're traveling on vacation, most of the time, as long as most of the time, Medicaid will not object to the cost of the person, the beneficiary, and one caregiver on that vacation for those expenses to be covered most of the time. Now, where I've seen some objection is, when you end up having a room that far exceeds the necessity for maybe a family of 3, and instead of paying for the caregiver plus the child, you have a room that maybe could sleep like 8 or 10 people because it's a giant suite and it's like connecting rooms. They're going to object to things like that. And so again, the decision, it's made by the trustee, but it also has to be in, with a clear assessment of the person's needs, the nature of their disability, and understanding the nature of that activity. And so sometimes that means talking it out with an attorney. But in terms of a situation where, to pay it back, again, it's going to be something where it's egregious. Like, so, you pay for the entire family to go on the vacation. Well, they're going to want the other family members to pay their pro rata share back. Again, I mentioned the caregiver, like if you're renting a room and just you and the caregiver on the hotel receipt, but clearly it looks like it's for a whole bunch more people, there's going to be questions about it. Definitely. But as long as, a trustee is doing things that are, let's say, like reasonable based on the nature of everything that's happening, usually those expenses are approved.
And if I can just interrupt, I understand that some of you have asked questions in a Q&A tab. For whatever reason, I am not able to view that, at least not right now. So if you've asked any questions in a Q&A tab, if you could send them within the chat feature to me, that would be great, just so we don't miss any of those questions. But we have another one that just came in, Tina, which asks if there's a grace period between setting up an ABLE account and applying for services.
Setting up, okay, is there a grace period? No. So when you apply for services, it is a snapshot of what the individual has at the time of application. So that you can't change. And so in terms of the grace period, it's not like you can say, oh, it's on its way to the ABLE account. I mean, sometimes, yeah, again, it's going to be a snapshot of that moment. What are the assets? The bank statements. What are the totals in those accounts? What other assets do they have? Do they have savings bonds and things like that? And so in that regard, no, there's not. But in terms of setting up an ABLE account, generally, like I said, it's pretty easy if the person's already on SSI. If they're not, it does take a little bit longer, but it's generally, I would say, a fairly quick process. It's not something that's, when I say quick, it might be like a week or two versus when you are setting up a first party special needs trust. Not only is there the drafting and the preparation of all that on the attorney side, but then once you file it with the court, it could be 4 to 6 weeks before you have an order. So that's likely to take maybe 2 to 3 months from start to finish. So on setting up the ABLE account side, it is definitely a quicker process. There are occasionally, I've heard of families that have some delays with documentation and things like that, but generally that's quick. But no, there's not a grace period for that.
Are there any restrictions on transferring funds from a special needs trust to an ABLE account?
The restriction is you cannot, there's two. Well, the first is that the restriction is any expenditure out of the special needs trust, we have to give that notice, right? So that's the one that we need to make sure that we comply with. The other one is we can't transfer more than $15,000 per year into the ABLE account. And so that's the second restriction that we have. As long as we provide the notice and we do that, there's not a restriction on doing that. And again, if you wanted to do, 15,000 this year and then, January 1, do another 15,000, you can do that. Like you can transfer that again, as long as you're complying with, the rules of providing notice and waiting that time out. But outside of that, there are not restrictions.
And there was actually a second part of that question, which is, am I correct in assuming that ABLE accounts are not considered for determining eligibility for any state or federal housing assistance programs?
They are, as long as the requirements, obviously the requirements being met for the person to be set up with it, meaning that their disability occurred prior to being 26 years old and they're able to set that up. The part of this account is to provide people with disability who are getting those means tested government benefits. So if they are, housing benefits for somebody with a disability who, then this is intended to, again, help them save money and use it as they need to, but help them put the money in an account that does not get counted for that. So, as long as it is for those purposes, then it would not get counted.
Can a disabled person's Roth IRA, which was earned before the disability, be rolled over into an ABLE account, or does it have to be withdrawn and depleted? So, the Roth IRA, as far as I've seen, because I like I said, 2017 is when they did the option with the 529 when that got passed to roll that over. I have not seen anything to roll over a person's Roth IRA. One of the things that could be done is to set up the first party special needs trust and then retitle the Roth IRA in the name of the special needs trust. This does open up a whole, sometimes some difficulty with getting
depending on where the account is held at, some difficulty in getting that retitled correctly, and definitely would work with the financial institution ahead of time, let them know what you're planning on doing to make sure that tends to be where we get a lot of pushback. But that's how you probably would handle a Roth IRA if you didn't want to deplete it, is to see about putting it into a first party special needs trust. But in terms of the ABLE account, I haven't seen anything for that with any pending legislation or anything else that's out there for that. I'm just flipping through because there was one other thing that I wanted to note. And there was, just on a separate topic, there was pending legislation for an ABLE account for a change to raise the age from 26 to 46. Now, that hasn't really gone anywhere. There was a couple times that I tried to get some momentum. There was some proposed legislation regarding that. But I do know that is a big concern for some individuals whose disability didn't manifest until after they were 26 years old. And so there was a push for that. So, but no, I haven't seen anything with the Roth IRA that would allow that.
All right. Can you assign a co-trustee together with a corporate trustee? And the second part of that question is, are first party special needs trusts and third party special needs trusts revocable or irrevocable?
Fantastic questions. Oh my God. All right. So first one, corporate trustee and a co-trustee, I'm assuming an individual as a co-trustee. Yes, absolutely. And I see that done quite a bit. One thing that I see done, I say quite a bit when people are considering to use the corporate trustee, with the co-trustee, what we see is that if the trust exceeds a certain amount, then we add on the corporate trustee. So there's language that usually says, I appoint my other son here to be the true co-trustee. But if this trust exceeds $500,000, I want a corporate co-trustee to serve along with him. And that's a great balance because that's a whole lot of money. And then you have the brains of that organization on how to invest it there. Want to hit on the revocable and irrevocable. Fantastic question. So the first party special needs trust, it's funded almost immediately after we set it up because it's a need right now. And so when we need it right now, it gets funded. Once it's funded, it's irrevocable. So it's almost essentially irrevocable from the beginning. Third party special needs trust, it becomes irrevocable only when it's funded. So if you set it up as part of your estate plan and there's no money in it, you can go ahead and change maybe your contingent beneficiaries, maybe change who you have as your backup trustees, revoke it, and whatever you need to do along the way, you can do that. Once it's funded, once there's money in there, it's irrevocable. There are some changes that can be made with amendments and things like that, but generally speaking, it's an irrevocable trust at that point. Yep.
Right. Looks like we have a couple more here. Is there a look back period when applying for Medicaid or DDD? How does this impact ABLE accounts?
Okay, so ABLE accounts are not, yes, there is a look back period. The look back period is 5 years for Medicaid. That does not apply to the ABLE account. So the ABLE account is a very specific account set up to allow someone to qualify for those benefits and to remain on those benefits. So it's a tool to help them. So that's not factored in. And generally speaking, in Medicaid, there is a lot of other, not a lot, but there are some other assets that are exempt that don't fall into that look back period. But generally speaking, there is a look back period. This does not factor into it. And then with the first party special needs trust, we're getting court approval to set that up and put those assets over there. So that's approved by the court to do that.
Would the monies placed into an ABLE account also be counted as income for SSI? For example, monies gifted or alternatively monies earned by the disabled person?
No, so that's the beauty of the ABLE account, is that the money that goes in there up to that $15,000 limit from others does not get counted. It does not get counted as income. If the person is earning their own money, they can contribute, instead of that $15,000, that limit goes up to the $27,140. Basically what that represents is the $15,000 plus the amount of the federal poverty income limit. So that's the maximum amount of the deposit. So it's like they can do 15,000 from others or themselves, or up to the 27,000 if they are earning income, and putting that into the account. So.
All right, I've got a follow-up question that someone had asked earlier. Can I start the process of creating a first-party special needs trust if I find out that my child will be receiving money, or do I have to wait until the money is actually received? And approximately how long does it take to get the court approval?
Okay, so what we want to do is, if we know there's a possibility, so when we say my child's receiving money, if the person's already passed away, nothing we can do to change that, start that process sooner rather than later. If the person's still alive and maybe they're named as a beneficiary of the will, the goal would be to see if we can get a third-party special needs trust set up where, again, you can control this. We don't have so much oversight, and have them name the third-party special needs trust instead of the child in their will. So that would be the great way to do it. If the money's coming from some other source and you can't control that, then that's where we do want to, and it's it's either in place or definitive. You want to start to get that ball rolling. Now, again, in terms of the timeline, the first part is getting everything drafted, getting the trust drafted that's needed, the complaint, all the supporting documents that are needed, the brief that has to get filed along with it. That usually takes a couple weeks internally in our office, revisions, client review, things like that. Then once it's filed with the court, it's like 4 to 6 weeks, depending on the court docket. They have been pretty consistent with how they're, moving cases forward, even through COVID. It's been really great in this area. We've been very impressed, but it does still, normal process takes 4 to 6 weeks, somewhere in that ballpark. So you might be looking at 3 months from start to finish, maybe a little bit longer.
Can you please clarify regarding the required notice for expenditures over $5,000? This requirement is for first-party special needs trusts only and not for third-party special needs trusts, correct?
Correct, because the third-party special needs trust, at the end of the day, when the beneficiary passes away, it goes to whoever you decide. The reason why we have to provide notice here is because the beneficiary of it is Medicaid. So they want to know what you're spending that money on along the way, and they don't want you to make a single large expenditure to try to deplete the assets. So they that oversight, because they are the beneficiary. So that's why it applies there. And I'll just keep in mind, in terms of the oversight for ABLE accounts, ABLE accounts are just, as a general matter, fairly new. And the language says that if you are overseeing an ABLE account for someone, you need to keep good records, you need to keep good bank records. They don't have the annual accounting requirement. They do send the balances. The balances are reported to Social Security on the monthly basis. So on the first of the month, that does get reported. But on the side of caution, if I were managing that from someone else, just use that same level of formality. Make sure you're documenting everything just the same, because you don't know if that will get called into question at all down the road.
All right, I think we got through all of the questions here. Does anyone else have any last-minute questions? Can I set up and transfer money into an ABLE account within the 5-year period and still apply and get services? How is this transfer viewed?
It's not true. So in that 5 year, it doesn't factor in. It's not part of the look back. So if you're putting it into an ABLE account, it does not factor into that look back period at all. So that's not, it's not something you have to worry about with funding that. So I hope that answers that part.
We have another question here. Can an ABLE account for a New Jersey resident be set up in another state, or do they have to go with First Third Bank? I think I just mentioned this before. You can set up an ABLE account in another jurisdiction, but it doesn't necessarily mean you're going to, circumvent the Medicaid payback provision, at least within New Jersey.
And they noted there the bank is, I think it's Fifth Third Bank is where the account is in New Jersey. Maybe they're not happy with that bank. In terms of doing it in another state, I don't know what those requirements are for even for other states outside of what we know about, and they may restrict it to their residents. So,
how can we protect our 401k funds from medical and nursing expenses in order to fund a third-party trust?
Say that one more time, because you froze right in the middle of it.
How can we protect our 401k funds from medical and nursing expenses in order to fund a third-party trust?
Okay, so that is, I mean, so that sounds to me like that's going down the whole elder planning for Medicaid, possibly that the person needs it themselves for Medicaid. And if that's what the 5-year look back is referring to, for the person's own qualification for Medicaid, not the disabled person's qualification for Medicaid, any payments into that ABLE account are going to be counted as a gift, because you're still making a gift to the person. They're just not going to count for the disabled persons when they are setting up and qualifying for Medicaid. But in terms of what can a person do to qualify for Medicaid, that's an analysis that's going to be based on the resources, what they have, how much they have, who needs to qualify for Medicaid, and really a whole different presentation than today what we're covering. But I don't know if that was connected to the other questions about the 5-year look back. But just to be clear, if you yourself are trying to qualify for Medicaid and you make a gift to somebody, it's still counted as a gift for your own 5-year look back. It's not going to count for that person who's receiving it, the beneficiary, for them qualifying on that end. So, and I know we're getting close on time, so we have one more question.
If anyone has any last questions, please submit them again through the chat box and not the Q&A box.
And I know I touched upon a lot where it overlaps with the third-party special needs trust, but I know tomorrow morning, like I said, tomorrow morning, my colleague Paul Pryor is talking on estate planning, and that's going to cover a whole host of other things, including the third-party special needs trust, probably in some more detail. So that's definitely something, if you had more questions about that and I couldn't get to them, go ahead and check it out. I know we have a lot of great other presentations throughout the day as well. I know Jared and I are talking about guardianships later on. And then we have a lot of guest speakers that we work with from a lot of great organizations that are here with us on our conference. So it's really cool.
All right. You know, again, I'm being told that there's another chat box, which I cannot see or view. So I apologize, but I am unable to, view or ask any of those questions. So again, if you have any questions, please submit them in the Zoom group chat, which will go directly to the host privately. We would ask that you submit them here. The chat box should be located on the bottom of your screen on the control bar. If you're using a laptop, along with the mute, the video button, the participants button, along those features. All right, Tina, just to clarify, wages earned by the disabled and deposited into the ABLE account will not count as earned income when calculating the SSI federal benefit. Is that right?
That is correct. Oh, I mean, it still counts as earned income. It does not, once it's saved in the account, so it's still going to count as income because he's earning that income, right? No matter where that goes. But when it goes into the ABLE account, it doesn't count as a resource. So that's where, to keep under that resource limit, that's where, if they're working, they would want to earn that. That's where it doesn't count as income. Then when they withdraw the money, it doesn't count as income a second time.
Let me ask you another loaded question, Tina, real quickly. First, is there a minimum for the ABLE account? And is there a fee charge to maintain an ABLE account?
I don't know if there's a minimum to open it. There are fees, and the fees are on the ABLE account website itself. I do know, like, it tells you the percentage there and what the monthly amount is for the account itself. So if you were to search NJ ABLE in the Google, like I said, you'd find the website for it. It has the information as to the link to open it, to set it up. Again, also would have the information about the bank, even information on there about what it can be spent on, and including, like I said, the fees and that information for everybody there. But I don't happen to know that off the top of my head.
All right. All right, here's a question. Please clarify that a New Jersey resident can open an account in an ABLE account sponsored by another state. I think we touched on that.
Yeah, so, I mean, first of all, outside of, where, Jared and I practice, we only know about the rules in our states, right? So I don't know what the rules are in any other state. But what, Jared was, mentioning with Pennsylvania is that, if you're a New Jersey resident and you go to open up an account in Pennsylvania to get around the Medicaid payback provision, that's not going to be allowed. So even though you may be technically able to open the account, it doesn't allow you, there'd be no other, benefit really to opening it up there versus here, because you still would trigger that. You couldn't open it for that reason. So in terms of opening it up, I don't know about any other states. I don't know what their requirements are or what they have there. And outside of that, I don't know how that's going to play out. So I can't answer anything more than on that piece.
All right, Tina. And the last one I think I just received is, grandparents' will has monies directly going to grandchildren. What can we do to ensure our special needs adult doesn't lose their benefits? Once money is received, can it be put into a trust without losing benefits? We can't get them to change the will. Okay.
So you hit on my first thing would be change the will. If not, unfortunately, when that money is received, depending on the amount, if it's under the $15,000, put it in an Able account, problem solved. If it's over the $15,000, that's when you're going to need to go ahead and get everything started for the first party special needs trust. That's the exact example of when that would be needed to go ahead and set that up.
All right, and I understand now that the Q&A box was on the conference website itself. So fortunately, we don't have that open. We're hosting this on the Zoom link. So we just have the access to the group chat. And I also just want to quickly mention before we conclude that the other two presentations, which were being run simultaneous to this one, they were having issues with people clicking the conference links and coming in. So at this point, we have emailed everyone who's signed up and registered for this conference. In your email, you will find all of the registration links. The conference website will no longer have them. We've pulled that link, those links from the site, because there have been issues. So if you would like to attend any of the conferences moving forward, please take a look at your email. You'll have access to all of the links there. So with that, I would just like to greatly appreciate and thank Tina, for this incredible presentation. There's been a lot of information provided. The other thing I just want to quickly touch on is, again, if you haven't already signed up tonight for New Jersey Supreme Court Justice Helen Hones' keynote address, I would highly recommend you do so, as you don't want to miss out on that important information. So with that, thank you very much, Tina. Thank you to all of you, and hopefully you found this information helpful. So with that, we hope to see you.
Thank you, everyone.
Take care.
Thank you for watching this encore presentation from the Fall 2020 Hinkle, Pryor and Fisher Parent Empowerment Conference. With 24 other presentations to view, there is plenty of additional information to help you become empowered. As a reminder, the information contained in this video is not a substitute for individual legal advice and does not create an attorney-client relationship. Copyright 2020 Hinkle, Pryor and Fisher, PC, Attorneys at Law. All rights reserved.